Good day and welcome to Epstein Becker Green's webinar, Federal Government Contractors and Subcontractors, Compliance with the OFCCP's New Regulations under VEVRAA and the Rehabilitation Act. We are pleased to have two fantastic speakers today, Epstein Becker Green's Dean R. Singwald, who is an associate in the Labor and Employment and Litigation Practices, and Peter M. Stein, a member of Epstein Becker Green's Labor and Employment Practice. Before we begin today's webinar, please be informed that today's webinar is being recorded and that participant phone lines will be in listen-only mode throughout the program. You are welcome to submit questions throughout the program by using the Q&A or chat features provided by WebEx, which can be found on the right-hand side of your screen. At the end of the program, with time permitting, the speakers will address your questions. You are also welcome to submit questions directly to the presenters following the webinar, and contact information will be displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. At this time, I'd like to turn the webinar over to Peter.
Thank you, Kirsten. Thank you very much. So today's program is entitled Compliance with the OFCCP's New Regulations under VEVRAA and the Rehabilitation Act, What You Need to Be Doing Now. That's actually the program for over the next 2 weeks, and today we're going to focus simply on the VEVRAA part, and 2 weeks from now we'll be doing the rehabilitation part. Dean and I will present the program. And again, this is part 1, Noteworthy and New Vietnam-Era Veterans Readjustment Assistance Act Regulations. I am always amazed, I'm going to go back, I'm always amazed how the words affirmative action or OFCCP, or even worse, compliance review, can cause a seasoned HR professional's knees to buckle. While it may, and in fact does in many instances, it really shouldn't. Affirmative action is just 2 words. Affirmative action, taking proactive, positive steps to assure non-discrimination. In this case, non-discrimination against veterans. As many of you already know, last spring, new Department of Labor regulations regarding the implementation of affirmative action plans under both VEVRAA and the Rehabilitation Act, the first substantive changes since the 1970s, became effective on March 24, 2014, to be specific. Over the next 2 weeks, as I mentioned earlier, Dean and I will be reviewing with you those changes about which you should be aware and reminding you of those existing policies and processes that do require your attention. Since we have only a limited amount of time with you today, we'll dive right in. I wanted to bring to your attention initially the fact that just 10 days ago, or a little more than, I guess, about 2 weeks ago, the OFCCP published a new scheduling letter. That is the letter that employers, contractors get when the OFCCP is scheduling a compliance review. The cover letter remains substantially the same, but the attached itemized listing has been significantly expanded, with more direct inquiries about the contractor's affirmative action efforts towards the employment of veterans. And you see on your slide the new, and by the way, the old itemized listing were a total of 11 items that they requested. Well, number 11 used to be the compensation data. Now there are 22 specific inquiries that they're asking you to respond in this itemized listing. And items 11 through 14 are very specific to your new obligations under VEVRAA. Item 11, they ask for a specific for the contractors who specifically evaluate the effectiveness of your outreach and recruitment efforts. What have you done in the past year to reach out to employ and retain employment qualified veterans? Both Dean and I will touch on that later on in the presentation, the specific section that deals with outreach and recruitment. They ask for documentation of all actions taken to comply with the audit and reporting system requirements in the regulations. Dean will address that later. Number 13, they want you to document documentation of the computations or comparisons described in a specific section for the immediate year. And this is the data on hiring veterans. Dean will address that later on also. So they want specifically for you to respond to these items. And number 14, documentation of the hiring benchmark that you adopted, the methodology used, and we'll talk about that later. And if you're 6 months into the plan, information that reflects your current year results. So these are very specific questions that will need to be answered in the next round of compliance reviews when contractors get this new scheduling letter. And by the way, if you want this scheduling letter, you can email us and we will send you, you can get them online, but if you can't find them, we can obviously get those scheduling letters to you. These revised regulations, that are effective March 24th, you see, just so you know, they are only effective as we speak for plans prepared after March 24th. Those plans prepared after March 24th, 2014 must comply with these new regulations. If you prepared your plans prior to March 24th, you can wait until the next annual cycle to come into compliance. So if you drafted a plan in April, that should be consistent with the new regulations. If your plan was written in February, you can wait until next February to make sure your plan is in compliance with these regulations. As was the original intent of VEVRAA in 1974, it's been a long time, this just continues the process of social engineering, these new regulations. That is, how can we best, how can the contractor community best support the employment needs of our returning veterans? Those men and women who devoted, in many cases, the best years of their lives and sometimes their limbs, unfortunately, to the service of our country. It's the first significant change since 1976 of the regulations, and that's a long time. And of course, we all realize that post-Iraq and Afghanistan, there are an increasing number of veterans returning to the workforce. And we all hope, of course, that they don't get sent back in harm's way. The data is clear that the veteran unemployment rates runs 2% higher than non-veterans, 3.6% higher than Gulf War veterans. That male veterans earn 2.7% less than non-veterans. Interestingly enough, female veterans seem to earn more than non-veterans. But the bottom line is that we have to take steps as a community, as an employer community, to assist veterans entering into the workforce. We have that duty. The applicability of these new regulations are only applicable to those contracts of $100,000 or more, which is different from Executive Order 11246 and the Rehab Act, which is $10,000. These new VEVRAA regulations specifically apply only to contracts of $100,000 or more. And the citation date is 60-300.1. If you're taking notes, you should add 60-300.40A, where it very specifically states that. There's a new equal opportunity clause, broader and more expansive than prior years. One of the new requirements in the equal opportunity clause, which is the clause that really in effect is in every contract. The government contract that you sign with the government has this language in it verbatim. It's not optional, it's quoted, and it states in every government contract in excess of $100,000, the clause, equal opportunity clause, which is actually sections, there are 12 sections to them, and you'll see that on the next page, must be included in every government contract. But what's new in the equal opportunity clause is the statement that the contractor must, in all solicitations or advertisements for employees, state that all qualified applicants will receive consideration for employment without regard to their veteran status. So they want you to pronounce it. They want the world to know, the applicant pools to know, your recruiting resources to know that affirmatively you will not discriminate against individuals because of their veteran status. That statement has always been required under the 11246 regulations for minorities and women, but now it's also being required in both the VETS regulation and the disabled regulations for the affirmative statement that you will not discriminate on disabled or veteran status. And in the past, many of us use short form. We might write an equal opportunity employer, MFDV, which stood for minorities, females, disabled, and veterans. They very specifically, I guess, they determined that people really didn't know. Perhaps they knew what MF meant, but they didn't know what DV meant. So to be very specific about what D and V means, they want you to spell out the words disabled and spell out the word, at least use vets. And that issue of using the word vet or veterans or vets can be found at the frequently asked questions. I've given you the website to find that. I want to remind you under this Equal Opportunity Clause, and it's always been there, but it's one of the areas where many of our clients find themselves lacking in compliance, is that we've always had an obligation to list all employment openings with the, quote, appropriate employment service delivery system. That's a long-form name for the state employment service, whether it's New York State, New Jersey, Connecticut, the state employment service. You must list all your openings. There are exceptions in the next bullet for executive and senior management, those positions to be filled from within, and positions lasting 3 days or less. But there's always been that obligation, and again, we find in many of our compliance reviews and reviewing this with our clients that they're just not complying as they should be. And of course, that does come up in compliance reviews. And all it does is require us to list those jobs with the State Employment Service. It doesn't require us to hire from the State Employment Service, but each State Employment Service has a Veterans Bureau that focuses on making sure that they give perhaps preference to sending veterans to open positions to which they become aware. What's also new, as part of that posting with the State Employment Service, there were some additional requirements that didn't exist prior. Now they have some new requirements, and these things are not difficult to comply with. Perhaps the first year you have to read through the requirements and determine what you have to do, but once you've done it the first year, the second year, the third year, and subsequent years, this really becomes very easy once you develop the protocol. But what's new, as I stated in the slide here, in addition to the notices previously required to be provided to the Employment Service Delivery System, again, the State Labor Department, that is, we used to always had to give them name and location of each hiring location within the state. There's an additional requirement existing for contractors to identify itself. So we must tell the State Employment Service that we're a federal government contractor and that we, quote, desire priority referrals of protected veterans. We're required to say that. And we're supposed to identify the contractor official responsible for hiring at each location. And in the event we use any external sources, the contractor shall provide the contact information for those organizations. So this just broadens the notice requirement that we've always been required to give to the State Employment Service when we have job openings that don't fall into the category of senior and executive positions, those filled from within, and 3 days or less. But every job position that's open otherwise is supposed to be listed with the State Employment Service. And you can do that online in the 99%. I can't speak for all 50 states, but certainly in the Northeast, you can do it online. It's something that we should be doing, and I would encourage you to make sure your protocol exists so it is being done. I mentioned the clause, the Full Equal Opportunity Clause, sections 1 through 12. Again, that's the clause that's actually in the employment contract, whether it's in the contract itself or it is there by reference. It is there in every government contract. And they state that the full clause isn't necessary to be included verbatim. You don't have to include that clause. And this, by the way, goes to whether you have subcontractors or applicable, applicable subcontractors. Sometimes you can include the clause 1 through 12, or you may substitute the language that's in bold, and it must be in bold. The bold is not optional. The bold is required. This contractor and subcontractor shall abide by the requirements of 41 CFR 60-300.5a, which is the Equal Opportunity Clause. This regulation prohibits discrimination against qualified protected veterans and requires affirmative actions by prime government contractors and subcontractors to employ and advance in employment qualified protected veterans. That's all well and good. It's mom and apple pie. It's what we should be doing for these folks.
Now, excuse me, this is Dean Singlewald. Thank you again for joining us. As Peter indicated at the beginning of the presentation when showing you the scheduling letter and those 4 new additional requirements, obligations that have to be adhered to when responding to a compliance review, the OFCCP is very much interested in getting veterans hired and and while contractors have always had that obligation to engage in outreach and to improve the hiring of veterans, these new regulations really are to ensure that we're taking proactive steps to really engage in this outreach because of the fact that if subject to a compliance review, we're going to have to be documenting our efforts. And if we're not documenting our efforts and unable to demonstrate what we've been doing, then we're going to be cited for violations, and the remedies going forward are going to be you need to be documenting your efforts and you need to be making efforts. So one of the things that has been required in the past and the regulations have expounded upon is this invitation to self-identify. And I want to highlight a couple of points before going through. As you can see, there's a pre-offer phase, a post-offer phase. But I just want to mention a couple of things in terms of what's changed with the regulations. As you may recall, we've had 4 types of veterans that are classified that are protected. In the past, we've called them covered veterans. The OFCCP has now actually defined specifically that you have protected veterans, and they are disabled veterans, recently separated veterans, active duty, wartime, and campaign badge veterans. And that's a change. That used to be called other protected veterans, and no one knew exactly what they were talking about, even when reading through the definitions. So there's been a change there in terms of the listing. The 4th one is Armed Forces Service Medal Veterans. So while the categories haven't changed, the name in at least one instance has changed. There is criteria that identifies, provided by the Office of Personnel Management, that will actually tell you what are the active duty, wartime, and campaign badge veterans. And it certainly, if anyone, and through some searching you can find it online, but if anyone's interested, we'd be more than happy to provide that along. Just shoot us an email. But I want to mention that and then delve into these 2 invitations. In the past, you were obligated to, after making an offer for employment, invite a candidate to self-identify, voluntarily self-identify their veteran status. Now, the OFCCP has 2 objectives. The first is to measure the effectiveness of your outreach and recruiting efforts. And so what they want us to do at the pre-offer stage is invite candidates, applicants, to identify simply whether they fit into one or more of the classifications of protected veterans. So I just gave you the 4 classifications. Applicants don't have to identify which of those they are, but at the pre-offer stage, they need to be able to have the opportunity to identify whether they or not they fit into one of those categories. And again, that's so that you'll be able to measure your effectiveness in terms of outreach and recruiting. Once an offer has been made, you have to again submit another invitation to self-identify, slightly different in format, contains the definitions again, but it will tell you that the purpose for this invitation is for the reporting that's required, and as you may know, there's a VETS 100 and VETS 100A obligation, and we'll talk more about that. There's a new number, a new reporting obligation coming up down the pike. But this second invitation to self-identify is specifically geared towards having the individuals have the opportunity to identify which of the 4 categories or more they fit within. It also is an opportunity for applicants at this point in time, these are the post-offer, to be able to identify if they wish, if they are disabled, whether they need an accommodation. So it gives them an opportunity to tell us whether they need an accommodation. It's contained, that language requesting that they make such ask is contained on the form itself, and we oftentimes say, you know, that's sufficient to allow them then, after they receive that invitation, to come to you if they want to seek out, in fact, an accommodation. And I should also say, before moving on to the next slide, that these forms indicate on there that they're going to be maintained confidentially. And we'd be happy as well to send you templates of the forms, not only for these 2 that I've just referenced for the veterans, but also for the ones that we'll talk about in a couple of weeks for disabled. Now, what's also required, a new requirement through the regulations, is data collection. And it frankly stems from, and you're going to get this data from the invitations to self-identify. And as you can see, it's very generic. It maintains here that you need to identify, for a period of 3 years, the number of applicants who self-identified as individuals with disabilities or who are otherwise known. Maybe they don't self-identify, but you know that they were a veteran, so you need to fill that out. They'll also have you identify the total number of job openings and total number of jobs filled, the total number of applicants for all jobs, the total number of applicants that are veterans who were hired, and the total number of applicants that were hired. And the whole purpose behind this is data gathering, but although there is no requirement to do this, we see it as something on the horizon, and that is to do an adverse impact analysis. As you presently have an obligation to do with your applicants and hires, your promotions and your terminations, you need to do an impact ratio analysis to determine whether groups are being treated consistently or if there's being disparate treatment. So with the data that we've collected, you actually have the opportunity, although it's not required, to do an adverse impact analysis so that you can see whether you have the percentage of protected veterans you're hiring versus the percentage of non-veterans who are being hired. And if there's significant disparities between those percentages, then it allows you to ask the question, well, why is that the case? And you're able to turn around and drill down, much like you do with your Executive Order 11246 plan, you'll now have that opportunity to do with your vets. And as I mentioned before, the information that you're tracking here needs to be kept for 3 years.
I'm going to, this is Peter Stein, going to talk about reasonable accommodation obligations under the regulations, which aren't significantly different from what existed in the past. But I want to point out something that's been there for a long time, and it's really not new, but again, one of those areas where I have found in my experience, like the failure of many of the contractors out there to list their employment openings, is the failure of employers to keep good records on reasonable accommodation. This section you'll see here is really affirmative action at its most affirmative. And again, my instinct that it's not universally followed, but it's not new. If you look at the requirement very carefully, and it's very clear, this is if you're a government contractor, the actual regulation starts off, and they use the words affirmative action. They say, as a matter of affirmative action, and they go on to say, if an employee who is a known disabled veteran, this is really not across the board for all protected veterans, but by the way, this language is also found in the Rehabilitation Act regulations. This goes to disability, which is obviously reasonable accommodation only goes to disability issues. Reasonable accommodation doesn't go to someone who's simply a protected veteran, but if someone is disabled, disabled protected veteran, then we have reasonable accommodation obligations. So if an employee who's a known disabled veteran is having significant difficulty performing his or her job, and it is reasonable to conclude that the performance problem may be related to the known disability. Again, it may be obvious to you, or they have indicated in their post-offer ID that they're a disabled veteran. So someone's having a performance problem, and you believe it may be related to that known disability. The contractor, the employer, shall confidentially notify the employee of the performance problem and inquire whether the performance problem is related to the disability. If the employee responds, yes, it is, affirmatively, the contractor shall inquire whether the employee needs a reasonable accommodation. Now, this goes beyond the ADA requirements of non-government contractors and is somewhat counterintuitive. The intuitive response for employment lawyers and people in HR is to remain focused on the performance problem and not to make inquiries into whether the performance problem is related to the disability. But this is an affirmative step. They want us to take this affirmative step, that if someone with a known disability is having performance problems, we must raise the issue and must ask if it's related, and if it is, what can we do? What accommodations can we make? Now, we don't have to make the accommodations. Then you go to the issue of whether they're reasonable and whether they present an undue hardship, but you must engage in the interactive process. This is what the Rehabilitation Act has required for years. And again, there's nothing new in the Veterans Regulation about this, but my sense is that many employers don't do this, that they do not affirmatively, well, they may not even know who is disabled at this point, but when they do know that someone's a disabled veteran and that person, has a performance problem, they have to confidentially address it and raise the issue of disability. So if someone's someone has narcolepsy and is starting to come into work late on a regular basis, the regulation would, I believe, require you to say to the person, John, I noticed that you've been coming in late recently. Is this related to your narcolepsy? And if it is there any accommodation we can make for you? Which might be, I need to come in late. That may not, there may not be a reasonable accommodation, but the question whether on that issue depends on whether it's an essential function of the job. But again, if you look at this carefully, it does really require real affirmative action, making this a real issue. The Veterans regulations on reasonable accommodation, again, have always required it, unless there's undue hardship. And we suggest that you develop and maintain a separate log, confidential of course, separate file, separate log, where you can keep in one place a list of those reasonable accommodations which you have made to disabled veterans or disabled individuals in any event under the Rehab Act. But I think it's important to do this in advance and not wait until this becomes an issue, until the government asks you in part of the compliance review, well, what reasonable accommodations have you made? And I think when we actually drill down with our clients about what accommodations have been made, there are many, there are dozens, there are hundreds, there are thousands of accommodations that we make on a regular basis, and we really don't even think they're accommodations. Whether someone says, I have a bad back, and you get them an ergonomic chair, or someone says, I'm having difficulty as I age reading my video display, and you get someone a bigger video display. Or you provide special lighting, or give them a special lamp in their work area. Or you provide an air purifier because someone says, I have an allergy to certain scents. There are lots of accommodations we make that we really sometimes, they're not the big ones. They're not obviously making the facility wheelchair accessible of those types, but there are literally dozens of accommodations that we sort of make on a regular basis, and we really don't even know we're making them. Just as I'm smiling as I'm saying this, a dean here a couple of years ago, or maybe now it's 4 or 5 years ago, came to me and said, I thought he said, that his back was bothering him, and could we provide a workstation where he could stand for part of the day. I didn't think of it as a disability, but now that looking back in hindsight, if I kept that log, I would keep a log and say yes, because I did. We did accommodate Dean, and he asked because of what I thought of a back problem. We provided him a special standing workstation. And I would keep those that information in a special log. And in fact, I think, Dean, you told me in our employee data spreadsheet, which we provide to clients when we prepare affirmative action plans, one of the cells we can be populated is have reasonable accommodations been asked for and have reasonable accommodations been made to this particular employee. Again, that employee data spreadsheet is confidential, used only to prepare the affirmative action plans. But I think it's important for you to start thinking about, again, you don't want to wait till the last minute, because sometimes, unfortunately, with the OFCCP, when they do a compliance review and they send you the letter and say we want additional information, no matter how long it sits on their desk, whenever you get the letter, it says, we expect your response in 6 days or 5 days or in 4 days. And sometimes, you have to sit back and think, well, what accommodations have we made for employees over the last year, 2 years, 3 years, et cetera. So I would encourage you to start keeping that, again, confidential, of course.
And just so you know, since the regulations have gone into effect, during audits, they are now requesting that you provide them not only with a list of the accommodations you provided, but also who you provided it to.
Then there's a section on external dissemination of policy, outreach, and positive recruitment. Again, this is an affirmative action obligation. They're requiring, the contractor must send written notification of the company policy on affirmative action for the protection and employment of protected veterans to all, not some, not many, subcontractors requesting appropriate action on their part. And just as I noticed there is a small typo in that citation. It should read 60-300.44F1. Double I. It's a 1 instead of an II. So it's 1 double I. In prior regs, in the regs prior to March 24th, 2014, this was a suggested optional action item. Now it is required. And on an annual basis, the contractor shall review and evaluate the effectiveness of the outreach and recruitment efforts taken over the last 12 months. So they want, and that's part of, you go back to the itemized listing, that's what they're asking for. They wanted you to evaluate your outreach and recruitment efforts. And again, this is all about affirmative action. You want to try to hire more veterans if we can. And what do you do to do that? You engage in outreach. You engage in recruitment. You try to partner up with advocacy groups that assist veterans. And formalize those relationships. You don't have to hire from those folks, but you want to consider those applicants. You want to make sure that protected veterans are in your applicant pool. The contractor shall document each evaluation, the criteria used to evaluate the effectiveness, and a conclusion as to whether the efforts were successful. So they're just asking you to do the obvious. See what's working, what's not working. And if you determine that your efforts were not successful, then you shall identify alternative efforts. And Dean will speak a little to that in a moment. And of course, similar to the other requirements of maintaining records, your efforts of external dissemination, outreach, and positive recruitment shall be documented and retained for a 3-year period. So again, this is sort of mom and apple pie. And again, the first year it may be difficult to develop those relationships, but once you do, it becomes very easy. It's like riding a bike. Difficult the first time when you're taught, but once you get your balance and you're doing it, it's very simple. If you see the next page, by the way, in terms of resources, I pulled up a site that I would suggest everybody use. And this, you see the citation, www.ebenefits.va.gov, etc. You see it at the top. And this is a web address where it's part of the Veterans Affairs Department, and welcome to the Veterans Employment Center for employers. See that in the middle. And you can either search for veteran profiles if you're searching for certain skills you're looking for that veterans perhaps will match. They'll match them for you. Or you can post a job. This does not replace the state employment service, but it's just a form of outreach, in a form of creative outreach and recruitment to use this particular site.
And expounding upon that, as we've just been talking about, you have an obligation to engage in outreach and recruitment. Peter's just highlighted the e-benefits site. The OFCCP now provides a link. We've provided it to you here on the slide, a page that has gathered together different resources for you so that you can meet your outreach and recruitment obligations. And going through them slightly, what you see is a screenshot of the internet web page highlighting 4 of the veteran organizations. There's an additional 7 that are listed. One of the reasons why I put this slide here for you is because in the past, when talking with clients about their obligations to engage in outreach, it's always difficult to figure out how to get started. And this is a great starting point. You, just as I would, are going to be Googling to figure out how we can identify organizations within our area. And now with this resource made available by the OFCCP, it gives us a good starting place. As many of you may recall, we've had in the past a national website where you would make your postings, the Americans Jobs Bank, and that's no longer effective. But there have been other sites that have popped up. And it changes from time to time, as you'll see in a moment as I go through this list. Right now you have something called the Americans Job Center, which is a central database offering positions around the country. So if you were to turn around and take advantage of this resource, you would be posting to a central database which would allow people from all over the country to identify where you were located and what opportunities you had available to you. Another great resource is Career One Stop Business Center, which provides and gives you access to the different state job banks. We talked about the Employment Service Delivery System. The Career One Stop Business Center is going to provide you links to all the different states so that where you have facilities and positions open, you can be easily posting open positions to those state job banks. And just so you know, for those who aren't aware, with the technology advances improving day by day, there are now opportunities where, and you'll have to do some digging to figure out how to get this done, but there's opportunities for you to post on your intranet, or on your website, I should say, and have that automatically populated into some of the different state resources, so that it's a one-stop and you're having your postings dissipated to several different locations. Also here you have you'll see Disabled Veteran Outreach Program Specialist. That's actually been discontinued. So, and then you see the next one, Hero 2 Hired. That's actually been transitioned to the resource that Peter just made reference to, the e-benefits. So my point in just highlighting that is here you have a very recent website page made available to contractors, and there's changes already going on. So it's always wise to be able to go back and look into it and see what different opportunities you have for you.
And I'm going to add one thing here, and it's nothing to do with outreach, but unlike minorities and women, where it is doubtful, and in fact the regulations say you cannot discriminate against anyone because of race, color, creed, sex, national origin, that all employment decisions must be made on non-discriminatory factors. Interestingly enough, and we'll talk about it in 2 weeks, the The Rehabilitation Act regulations have a specific section saying that there's no claim for, quote, I'll use the word reverse discrimination, which I always say is a misnomer. There's no such thing as reverse discrimination. It's discrimination on the basis of race, color, creed, sex, national origin. But the rehab regulations specifically state that there is no claim of reverse discrimination if you hire a disabled person and give them a preference over a non-disabled person who may be more qualified. There's no cause of action by the non-disabled person if they don't get hired by saying, hey, I'm non-disabled, I should have gotten that job. It doesn't exist. No, even though it's not in the VEVRAA regulations or in VEVRAA itself, and I don't know why they made the distinction of including it in the rehab regulations, not in the VEVRAA regulation, but that's also true. So you can engage in outreach, but you can also give preferences to veterans. If you want to hire someone who, you know, is maybe a little less qualified than somebody, hopefully you'll never hire someone who's unqualified, but if you have two equally qualified candidates and you want to give a preference to a veteran because, again, they have given up part of their lives in service of our country, you can do that. And there shouldn't be, and there is none, no reverse discrimination claim in that vein.
Now, we've just been talking about the external efforts that you're going to be making as a company. You also have to you have some obligations now internally as well with the new regulations. You need to have a policy in place. Most of you do, equal employment opportunity policy, but you need to make sure now that it's specifically spelled out that as a government contractor, you're going to, it's your policy to not engage in discrimination and to take affirmative action towards protected veterans. And that policy, the language needs to be within the policy, and you need to have that policy within your employee manual. So you'll need to review your employee manual to make sure that you have an updated equal employment opportunity policy. Another requirement is that the company's top U.S. executive, so for many of you it's going to be a CEO, for others it's going to be a senior executive, you need to include within the equal opportunity policy reference to the fact that that individual supports the policy of affirmative action as it relates to covered veterans. You have the same obligation as it relates to individuals with disabilities.
Getting senior management support has always been a key to real affirmative action. Getting top management support, and of course, this just having the policy drafted where the senior executive's signature is on it is just one component of that.
Now, our next requirement in terms of audit and reporting systems, there's only been one change to this, and we've already addressed it, and that is your obligation to document your efforts as it relates to affirmative action for protected veterans. The first several bullets, which we have combined here within this first paragraph, to measure the effectiveness of a contractor's affirmative action programs, to indicate any need for remedial action, et cetera, et cetera. These are all parts and obligations that you were previously obligated to do, but now they're putting more teeth into the matter, and they're saying, as we've already touched upon, if you're subject to an audit, you're going to have to show the documentation that supports the effort that you've made. Now, one of the things that I think is important to highlight here with the first measure, it's the measure of effectiveness of your contractor's affirmative action program. That is the data collection that we talked about earlier. Indicate any need for remedial action. That you're going to know. You're going to look at how your workforce is shaping up, how you are, and what your success rate is for hiring protected veterans. And you're going to evaluate that system. If you're not hiring a percentage of protected veterans, you're going to want to look at your selection processes and document that. Another interesting degree, determine the degree to which the contractor's objectives has been obtained. That's the adverse impact analysis, which we described earlier, that is possible to do with the data that you've collected. Determine whether known individuals with disabilities have the opportunity to participate in all company-sponsored educational, training, recreational, and social activities. Wow. they are now, as part of your compliance review, going to be asking you if you can provide them with assurances that that covered veterans have had the opportunity to participate in company-sponsored educational, training, recreational, social activities. We have not seen that yet in any audits, but it's something that you need to be aware of and need to be thinking about protocols that you can put in place so that you can identify whether or not protected veterans who you've identified within your workforce are being provided with these opportunities. And the second to last requirement is measuring the contractor's compliance with your affirmative actions program-specific obligations, and that's comparison of your data versus the benchmarks, which Peter will talk about shortly. And the new requirement out of this whole provision is what I alluded to before, which is the need to document the actions taken to comply with all of these obligations. And for this, the amount of time needed to keep records is 2 years. Now, next slide, please. Responsibilities for implementation. Many of you do this now. We wanted to highlight specifically the requirements to it. It's not a new obligation, but there's, again, more teeth in this. What you need to be able to do is have affirmative action administrator assigned, and the important thing here is that the person's identity needs to appear on any internal and external communications. So what the OFCCP is really saying is, look, we want an affirmative action administrator who's going to have a stake in this program and who's going to be identified and identifiable so that the hope is that they will engage in the affirmative action obligations they need to satisfy the requirements. What's important to note, the regulations also provide within this context that this affirmative action administrator must be given senior management support. It's within the obligation, within the regulations, and it also says, interestingly, and I think this is going to become more of an issue for companies as we get more involved with these new requirements, is you also, as an affirmative action administrator, must be provided with the staff to manage implementation of our program. So much of the talk in the past has been you're going to do the best you can with the resources you have available. And now what you really need to be mindful of is the government is coming around and saying, look, you need to have the staff in place to allow you to be able to implement the program appropriately.
I just want to add, look, over the many years that Dean and I have been doing affirmative action, and I've been doing it close to 30 years now, certainly in the vast majority of compliance reviews, the focus was on minorities and women. There will be a turn, or a turn is coming, or the times are changing, whatever you want, phrase you want to use. In upcoming audits, there will be much greater effort made to examine exactly what we're doing with regards to veterans and the disabled. I will tell you again, our experience has been, when we send in the affirmative action plans, we send in one for minorities and women, one for protected veterans or covered veterans, we used to call them now protected veterans, and one for the disabled. And I can't remember the last time we had any further inquiries regarding veterans or the disabled. Again, whether it's just a function of where they're focusing and putting their attention to, they clearly were not putting much attention to employers' obligations, even under the old regulations for the disabled and the veterans. And, you know, that's not an indictment, and it's not a criticism, it's just the way it has been. And it just, from the scheduling letter alone, you can see that much more emphasis, as it should be, will be placed on, in this case, what is the employer doing to encourage the employment of protected veterans? What outreach are you undertaking? What's worked? What hasn't worked? And many of it's, how can we help you? If you're not getting to where you think you should be, what can the OFCCP help you? And they're not all bad. It's not always that phrase that people, you know, we're from the government here to help, and people smirk about that. But in many instances, you will find that they are here to give you additional support in determining appropriate outreach and recruitment efforts for veterans.
So along those lines, training is another requirement too. Not something new, but again, something which just hasn't been focused on in the past, but really is I think, depending on the size of your organization, an important thing to pursue to ensure that people are on the right page. They understand what it means to have an affirmative action obligation. Outside of the preferences that Peter talked about, you're always looking to hire the most qualified person and not discriminate against others. And you want to cast a wider net. You want to improve that pool of talent that's available to you. By having a larger pool of talent, it increases the odds that you're going to be hiring a female, a minority, a protected veteran, an individual with a disability. So the training that you offer to personnel is important so that they're on the right page, same page with you. They understand that they're to ensure non-discrimination and your affirmative action efforts throughout the different stages of the process.
And I might point out that this program, as we sit here, as you listen, this is a training program. This is affirmative action. The people who are on the other side of this phone are people presumably somewhat involved in the human resource process. So this is an example. You could actually, put this in your affirmative action plan that you attended this program, because this is exactly the training they're talking about. Learning about your obligations so that you can implement those obligations. What is particularly new about the affirmative action regulations, both in rehab and VEVRAA, but we'll talk about VEVRAA for the moment, is new benchmarks for hiring. It never existed before, but now it does. And I don't have a problem with it. Again, I think it's part of the effort to revitalize contractors' efforts at recruitment of veterans. And they say in the regulations that the purpose of establishing benchmarks is to create a quantifiable. There was never any quantifiable veterans data except when you did the Vets 100, but to create a quantifiable method by which the contractor can measure progress towards achieving equal employment opportunities for protected veterans. That's the idea. And so what they want you to do is they've actually come up with, for the veterans, they will set an annual benchmark, and they have already set it. You notice they've written in there 7.2%. So the idea is that 7.2% of your hires should be protected veterans. And if it's 8.2%, you pat yourself in the back. If it's 6.2%, well, then you want to drill down. Why did we not meet that benchmark? Patricia Hsu recently said, she's the director, stated that, quote, failure to hit the benchmark is not a violation. Failure to try is. That's what they're getting at. We want you to try. It's not a goal. It's not a quota. It's neither one of those things. And by the way, the 7.2%, for those of you who want to see that, where that comes from, it was announced, I'm guessing, 3 or 4 months ago. And you can find it at, if you want to write this down, I'm sorry it's not on the PowerPoint, www.dol-esa.gov. So www.dol-esa.gov/ERRD. I'll repeat that, /ERRD/VEVRAA, which is VEVRAA.JSP. And that will get you to the VEVRAA benchmark database. It might be, you can get that if you go onto the OFCCP website and tool around a little. And if you type in benchmark database, you probably get to the same spot. But in that document, when you get there, at the very end, it'll show you the 7.2% number. Excuse me. The regs also state that, similar to the minorities and women regs, that the, quote, the benchmark is not a rigid and inflexible quota which must be met, nor is it to be considered a ceiling or a floor for the employment of a particular group. Quotas are expressly forbidden. That language is verbatim in the 11246 regs, and I assume I haven't looked recently in the rehab regs, but that definitely is the same language you find in the 11246 regs. Now, you can use the OFCCP gives you the opportunity to use the 7.2% number that they will publish on an annual basis, or if you so choose, there's a I think complicated formula in section 60-300.45B2. And just real quickly, you can establish that you can either use the number they give you, or you can establish the benchmark by taking into account, one, this is where it gets complicated, the average percentage of veterans in the civilian labor force in the states where the contractor is located over the preceding years. That's one factor. Two, the number of veterans over the previous 4 quarters who are participants in the employment services delivery system in the state where the contractor is located. 3, the applicant ratio and hiring ratio for the previous year based on the data that Dean referred to, those applicant flow data. 4, the contractor's recent assessment of the effectiveness of its external outreach and recruitment efforts. 5, any other factors. And then 6, you must document that hiring benchmark. So if you want to try to take those 1, 2, 3, 4, 5 factors and try to come up with a number, presumably something less than 7.2, and if you want to try to come up with a number higher, that's good too, that's good also, or you can use the number they give you as 7.2. My vote is to go with a 7.2. Again, it's a benchmark. It's something you measure your progress against. If you don't meet the benchmark, you don't get criticized. There's no foul. But the government wants to make sure that you have something in focus. It's really about focusing your attention. You want to focus your attention of employing 7.2% of the people you hire. I shouldn't put it another way. Of the people you hire, 7.2% you'd like to be protected veterans. With respect to the Availability Affirmative Action Program, the full plan, absent the data, the full plan, absent the data metrics, shall be made available. This is nothing new, except they added absent the data metrics. In the past, we never had data metrics, so there was not, it was nothing to talk about. So now, when you have to make the full AAP, absent those metrics, available to any employee or applicant for inspection upon request.
And lastly, we just wanted to highlight to you, and I made reference to that in the very beginning of the program, the change that has come about, and it's separate from the regulations that we've actually were talking about, a different set of regulations which set forth the requirements for the VETS 100 and VETS 100A report. New regulations have become finalized. Coming next year will be the VETS 4212. That's the section of the U.S. Code, VEVRAA. And that's where the name comes from. It's basically going to be the exact same reporting requirement as you've had in the past. I will say that it's probably the most overlooked reporting requirement that contractors have, and they want to put some teeth in it. So the one noticeable change I've highlighted here what your obligations are in terms of reporting, but you're going to have some different reporting obligations depending on your size, whether it's electronically or by paper. And the other point in here, which is not part of the slide, indicates that there's a new contract provision. So much like the Equal Opportunity Clause is supposed to be contained within your subcontracts, your actual government contract, or reference to it, there's now a provision in which basically you're notifying subcontractors you're working with that they've got an obligation as well to fill out this particular report. So that concludes our program. I'm not sure if there's an opportunity for questions.
At this time, we would certainly like to thank you all for your participation. And while we are wrapping up, please remember to feel free to email any questions that you do have to Peter and Dean, and any that have already been submitted, we will certainly address via email as well. And we do hope that you found today's session to be informative and that you can join us as well for part 2 of the OFCCP webinar series on October 28th. Again, thank you all very much for your participation.
Thank you.
Thank you.